Recording started.
Okay. Should I go ahead, or are you going to start, Nancy?
I'll go ahead and start.
Okay.
Thank you to Karen Strauss, Deputy Bureau Chief from the FCC, that is here with us this evening. Karen has been a long-time advocate for accessibility in terms of telecommunications for people with hearing loss, and we're very happy to have her tonight. Everybody should have captions that need them by clicking on the video screen, and the session is recorded in case you'd like to play back later. Go ahead and hit it, Karen. Thank you.
Okay, thank you. It's a pleasure to be here. I'm just going to lower my volume so there's no echo and get right started because we have a lot to cover in the next hour. A lot of times when I begin this presentation, I give an overview for people that don't know how important telecommunications is. I have a feeling that all of you do, but I thought this was a pretty slide and would put everybody in a good mood. So I'm showing you this very first colorful slide before we get down to business. Obviously, having communications means access to everything: employment, education, recreation, etc. I'm going to jump right into what I think many of you want to learn about, which is our brand new closed captioning rules. I have truly an enormous amount to cover in the next hour or 45 minutes. I'm probably not going to get through all of it. I am hoping to be at your convention, at the HLAA convention this summer, so whatever I don't cover or wherever I have to shorten, this is kind of a preview and a coming attraction, and I hope that you can join us at the HLAA conference. So this past February, after 10 years, we received a petition. The FCC received a petition 10 years ago. And actually, let me just give you a little bit of background. I'm not sure how much you know about me, but I've worked at the FCC for about 4 years now. I also worked in the Clinton administration for 2 years. In between those times, I consulted. And before those times, I worked for the National Association of the Deaf and Gallaudet University. So I've been working on communications access issues for, I'd say, a little over 30 years. So 10 years ago, approximately 10 years ago, HLAA was among several different consumer deaf and people with hearing loss associations that filed a petition with the FCC asking for rules to ensure that closed captioning on television was of a decent quality. And I'm sure that many of you out there have seen the quality decline in several years. In the past several years, the rules for captioning first went into effect, or actually the requirements for captioning were adopted in 1996. By Congress. The rules went into effect in 1998, and initially there were very few captioning agencies. There were 3 major national captioning agencies. After the rules went into effect, captioning agencies proliferated, and there was many people think that there was a race to the bottom in terms of quality in order to cut costs. Not everybody was providing poor captions. But there were a lot of stations that were, a lot of channels that were, and they were bringing down the quality generally. So as I said, about 10 years ago, a petition was filed at the FCC, and it took 10 years. We don't usually act that slowly, but this was a very controversial issue. There was a lot of opposition from especially the cable industry, some from broadcasters. So this past February, the great news is that we adopted quality standards. The quality standards are divided into 4 components. First, accuracy. Captions must reflect the dialogue and other sounds and music in the audio track to the fullest extent possible based on the type of programming. And I'm going to explain what I mean by type of programming in a minute. And also must identify speakers. For the most part, this means that the spelling has to be correct, the grammar has to be correct, the captions have to mirror what people are saying. So even if there is foul language used, it has to be provided. If numbers are used, acronyms, everything that's said, everything that people can hear has to be in captions. The second component has to do with timing. Captions have to be synchronous with their corresponding dialogue and other sounds to the fullest extent possible. Again, based on the type of programming, and also must appear at a speed that can be read by viewers. While we were working on the captioning rules, I happened to turn on the television and find old episodes of I Love Lucy, which I absolutely loved as a child. And I was delighted to see that they were captioned, because they're very old, and not all older programming has to be captioned. But my joy went away as fast as it came, because the captions were blinking on and off, and there was absolutely no way that I could read them. So while I was drafting the rules, I added this last phrase that must appear at a speed that could be read by viewers, because that was at way too fast a speed. I could not read them. So the timing has to be right. The next component is program completeness. When you watch a program, you want the captions to go from the beginning to the end. And finally, the placement. Especially around the transition to digital TV, we found that captions were covering up a lot of other important information on the screen. A lot of this had to do with the changes in technology, but it was pretty bad. And so what we've said is that captions can't cover up faces or text or graphics or other information that's essential to understanding the program content. And other information can't cover up captions as well. So I mentioned a number of times that all of these components are connected to the type of programming. For pre-recorded programming, those are your comedy series, movies, usually game shows, you know, everything that's not live. We're kind of expecting full compliance, because there's a lot of time to review the captions and to edit the captions. I'm going to talk in a second about how the entities that are required to comply with our rules, and by the way, those entities right now are the video distributors, they're the cable companies, the national broadcast networks, and the satellite companies. That's pretty much a summary of who's required to comply. They have an option of specifically complying with our rules or following some best practices that they gave us, and I'll talk about those in a second. The second type of programming is live programming. So the FCC has to consider, because it's only fair, the challenges that are involved in producing captions for live programming, because live programming, you type or speak as the captions are being conveyed. And so there's no opportunity to review or edit the captions. So we're going to be a little bit more lenient in terms of compliance with our rules. There may be more spelling errors, the timing is not going to be exact. And for that reason, some of the captions may miss the end of the program. However, we expect the captions to be sufficiently accurate, synchronous, complete, and placed to allow a viewer who depends on captioning to understand the programming to have a viewing experience that's comparable to someone listening to the soundtrack. And in our notice of proposed rulemaking, which is attached to the order, we ask, and I'm going to get to this in a second, we ask about other ways to make even live programming better in terms of captioning. There's something called near live programming, and that's a lot of times late night programming. It's performed and recorded within 24 hours prior to when it's first aired on television, and that programming will be evaluated under the same, like live programming. But again, we encourage certain measures like giving the captioners the material, the script in advance that are going to make captions on those programs even better. So I mentioned best practices. Part of the order has a list of best practices that video distributors can follow, and they can ask their programmers, their video programmers, and the programmers are basically, you know, the networks, for example. Those programmers have the agreements with the captioning vendors. They are required, if they choose to follow the best practices, to have in their agreements requirements for certain things, including error-free captions that are punctuated correctly, placed properly, and synchronized with audio, They have to do evaluations of their captioners and training and screening. They have to make sure their technical system functionalities are working right. So while you may be wondering what is the difference between the components and the best practices, they really do overlap, but the best practices are more focused on process. The components actually list, and if you look at the actual order, you'll see a whole list of specific ways to ensure accuracy, for example. And what we're going to do after about a year is evaluate compliance and see whether the best practices have worked for those entities that follow the best practices. In the meantime, we encourage you to keep watching captions. The rules have not gone into effect yet. They actually won't go into effect for until January 2015. But don't wait. Watch TV and start complaining. You can complain. We can give you information about how to complain. But if you do complain, make sure that you include this information that's on the screen. And I'm assuming that you're going to have access to this PowerPoint, and I'll make sure that you do through HLAA. So we want information about everything that's occurred, the channel name, the number. It says the name of the MVPD. The MVPD is the video provider, or rather the distributor, so your cable company, your satellite company, or a national broadcast network. We want to know the specifics about the date and the time when the captioning problem occurred, the name of the program, and really we need a detailed description about the problem. And we're going to be looking at these and determining what the problems are to see whether our rules need fixing. There's another whole component of the order that you need to know about, and that involves news programming. Right now, our rules require that real-time captions, in other words, captioning live, is required on major news programs if they're shown by the major national broadcast networks such as ABC, CBS, Fox, and NBC, or affiliates of these networks in the top 25 television markets. That's basically the top cities, the largest cities. Also by national non-broadcast networks, that's the cable companies, the satellite companies, serving at least 50% of all homes that subscribe to multi-channel video programming services. In other words, that serve at least 50% of all homes subscribing to cable and satellite. All other markets, all other cities can have local newscasts that use something called the electronic newsroom technique that uses the teleprompter, pre-scripted information that's put into the teleprompter that then is converted into captions. The problem is that because this is pre-scripted, it often misses live sports, weather, and a lot of breaking news, which obviously is not full access. So we have revised our rules to now say that you can continue using this ENT method, but if you do so, you have to make sure that you are pre-scripting most sports, weather, and late-breaking news. So you can't just use ENT and exclude all of that. Where you are not providing pre-scripted information, you have to use crawls and other visual information to provide visual access to segments where there's not captions. Again, we are going to assess the effectiveness of these new requirements and whether or not we need to provide requirements for real-time captioning, live captioning of news programs after a year. We are going to be looking for your feedback on this. We're going to be doing a lot of outreach across the country. These rules, by the way, go into effect 90 days after they are published, I believe, in the Federal Register. They have not yet been published, but that will come along soon. So that section of the order is going to be going into effect much faster than the quality standards. And by the way, we know that people are watching us and seeing whether our quality rules are going to be effective. I've already heard from people in Australia who have taken note, and I'm hoping that we can become a model for the world as we have in other disability areas. So there were a few other things that we covered in our captioning rules as well. Right now, video distributors already have an obligation to monitor and maintain their equipment. This is their captioning transmission equipment, not television, and to take any corrective measures that are needed to ensure that the equipment is working properly. And as part of this, or rather this is part of their obligation to provide captions to consumers. This is a fine point, but this obligation had been in a prior order that we issued. We had never put it specifically in our rules, so we've now done that. Gives it a little bit more oomph. We added a requirement, however, for video distributors to also perform routine technical equipment checks. So they actually have to affirmatively do some checks and make sure that their equipment is passing through the captions. We also added a requirement for these video distributors to keep records for 2 years of their activities related to the maintenance, monitoring, and routine technical checks of their captioning equipment. Let me clarify with that 2-year requirement. They have to do it forever, or at least until our rules change. But they have to keep records for any period of time for 2 years. So that obligation will not go away. Our order also clarified certain things about our current captioning rules. We always had rules for English and Spanish language programming. Our rules already say that 100% of all English and Spanish language new programming, that's programming shown after 1998, has to have captions. There are a few exemptions that some of you may know about. There's 4 hours in the middle of the night. There's an exemption for commercials that are under 5 minutes, and some local non-repeat, non-news programming like high school parades. We do have some exemptions, but pretty much everything is captioned. And that's in Spanish and English, and 75% of programming shown before 1998 also has to be captioned, whether it's English or Spanish. But what we didn't have specifically were rules for programs that are both English and Spanish, and those programs are now popping up. So we clarified that our rules apply to bilingual programming as well. However, if there's only a very small snippet of English or Spanish statements made in a program, then if it's only a small snippet in a program that is a non-English or Spanish program, so in other words, a program in French, Italian, Chinese, and there's a little bit of English or Spanish, it doesn't have to be captioned. All video distributors must make their contact information available to consumers and the Commission. We know that these are rules that already exist, I'm just clarifying. And also, on-demand programming. So video on demand, that has to be captioned with the same regularity as regular TV. So you need to know that. If you're seeing a program that's on demand and it's not captioned, file a complaint with us. And finally, low power stations must have captions as well. In our captioning order, we have something called a further notice, and that seeks comment, asks you to comment to us on whether to impose some responsibilities for compliance with these captioning rules on video programmers. Again, those are the networks, the channels, the stations, that to share the obligations. We also ask whether there are specific measures that we should require to ensure that programs are complete and timed right. Remember, I mentioned that we're relaxing our rules for live and near programming, but there are some methods, like for live programming, you could require the advanced delivery of the audio track. You could use fade outs to add a few seconds, like some sports programs have the American flag at the end, and it lets the captions run. You could perhaps, if the captions are flowing into a commercial, maybe they should be put at the top of the screen while the commercial captions are at the bottom of the screen so they don't overlap. For near live programming, again, late night shows, for example, maybe they can provide a complete program script or near completed program to the captioning agency. And by the way, these are all methods that are actually in use. They're just not required, but they're in use by some entities that are covered by our rules. And you could also provide access to the live feed taping to the captioning agency. So there are a lot of different ways to improve live captioning. Our notice also seeks comment on a lot of other issues, including how to define near live programming. As I said, we define it as any programming that's produced or prepared 24 hours before airing. Maybe it should be a tighter definition. Whether we should require offline captioning, that's captioning done, like captioning done for pre-recorded programming, not live, when an entity has to re-air live or near live programming. Should we require that when there's an outage of captioning that somehow that's communicated to viewers, maybe by a crawl along the bottom of the screen or in real time? It should be reported to the Commission. And whether the Commission should modify or eliminate some of our exemptions. We have a lot of exemptions that I mentioned before. They don't have that much impact, but one of the bigger ones is for new networks. Right now, new networks do not have to caption for the first 4 years of their existence. Commercials is another big one, and overnight programs are another, although that's less, it's not as a major an exemption because so much is repeated overnight, and our rules do require that if something's been captioned and it is repeated, it has to still be captioned again. We also asked about technologies for captioning 3D TV, and also whether everybody is getting access to the caption display features, accessing fonts, colors, sizes. I know that those are really hard to find on a TV, and so we want to start looking at that. So I'm going to skip over this slide. It basically just covers a lot of the different laws that we passed in the 1970s and 80s. I'm going to jump ahead to the turn of the century and just say that many of those laws that dealt with relay services and captioning, hearing and compatibility, they became outdated at the turn of the century because they weren't internet-based and they weren't digital. So there were no mandates for electronic messaging, such as emailing and texting, no mandates for accessible web browsers, no mandate for video description. Now, some of these deal with blind people, so I'm going to go over them pretty fast. But also, the biggest one for your population, and for me, because I'm a caption user, is that in the past, we had a law, and I'm going to go into this a little more, but as you know, in 1990, Congress passed the Television Decoder Circuitry Act. And that law said that every television with a screen at least 13 inches must have the capability of showing captions. Well, at the turn of the century, things started happening, and over the last 5 years, they've literally exploded. There are tablets in every size and shape. There are cell phones in every size and shape, and they're all with screens smaller than 13 inches. And we saw this starting to happen. And so we went to Congress and we said, you know what? We need a law to get rid of that 13-inch minimum. Also, of course, everything started moving to the Internet. Again, we saw this start to happening. So we said, you know, television programs are moving to the Internet. There's Internet-originated programs. What's going to happen when video is on the Internet? Are all captions going to disappear? So again, we went back to Congress, and again, we asked for a law that would cover programs when they go back on the Internet. And we got, and HLA, by the way, was very involved in this process. We got the 21st Century Communications and Video Accessibility Act. I hope that everybody in this web room has heard of this by now. It's called the CVAA for short. It ensures that people that rely on these other technologies or access technologies are not left behind. It aligns prior laws that focus on telecommunications and legacy technologies with current communications and video technologies. And it also fills in various gaps that were uncovered by prior laws. The bottom line, it addresses access challenges of 21st century technologies. So what does this law do? Well, it does a lot of different things, and I'm going to go through them in fair amount of detail, but probably not as much as I'd like to, and I'll do more at the convention. But I will tell you that over the last 3 years, the FCC has been very busy meeting every single deadline that we had, and we had about 10 different deadlines, 10 different rulemakings. We missed the last deadline by around 2 weeks. And I'm sure you can guess why. It was in October of 2013. The federal government shut down, and as the deadline came and went, I heard a collective groan of all of the people. There were about 100 people at the FCC that worked on these various proceedings. A collective groan that we could not meet the final deadline, but we like to say that we met every deadline that we could meet. And I'm going to go into detail now. And those checks are all of the deadlines that we've met. There are 2 on the bottom that didn't have deadlines. One involves access to 911 services, and the other one involves hearing aid compatibility. I'm not going to talk about hearing aid compatibility now because this is an ongoing proceeding. I'm hoping it's going to be finished by June. I don't know if it will be, but I will talk about what it's going to be exploring. Again, another reason to come to the convention. And by the way, HLA did not tell me to do this this convention promoting, but it's one of my favorite conventions, and so I'm hoping to see you all there. Okay, so the CVAA is divided into two titles. Some of you may have heard this one of the last times that I spoke, so I'm going to go through it quickly. The first one has to do with communications, and it requires access to basically any communication that's going to be taking place over the Internet, including VoIP, via Voice over Internet Protocol, electronic messaging. It includes interoperable video conferencing, but unfortunately there is no video conferencing that's interoperable. In other words, you can't use Skype to call FaceTime, so that one's kind of on hold. We're hoping that ultimately there is going to be interoperable video conferencing, and then we'll cover that as well. An industry can build in solutions into products and services, and they can also provide third-party solutions as well. And this is in effect now. Basically, it requires that services and products be accessible. It requires where services and products can't be accessible or where it's not achievable to do so, that they have to be compatible with assistive devices. And it also requires access to information and documentation about products and accessibility features. So, for example, let's say the way that you're going to be learning about a telephone is through a video. They'd have to provide captions, or they'd have to provide a transcript, that type of thing. This Title I also requires Internet browsers on mobile phones to be accessible to people who are blind and have visual impairments. And what's nice about the CVAA's Title I is that there are a lot of measures to ensure compliance. So there are new record-keeping obligations. Again, records have to be kept for 2 years, this time to show that there are about the products and services accessibility features and compatibility features, and efforts to consult with people with disabilities. We don't want industry just creating solutions in a vacuum. We want them to communicate with the communities that they're trying to serve. They also have to certify their record-keeping obligations to us annually, and they have to declare and verify the truth and accuracy of those those records. This is really important because we didn't have this obligation in the past for a comparable piece of legislation called Section 255, and compliance really wasn't that great for that section. We are already seeing a dramatic change in the way that companies are complying with this law, and we think that record keeping may have something to do with it. They also have to submit their contact information to the FCC it's in case you want to file a complaint. And I provide here the registry where you can find out where a company is. And the FCC also has obligations. We have to report to Congress every 2 years on progress and the status of compliance with Title I. So, of course, what's interesting is that we wrote this. I don't know whether you're aware, but I mentioned this before, but I was one of the people that wrote this law, and we put in that the FCC has to write reports, and now I'm writing the reports with other people who also wrote the law, and we're cursing that section because we have to do the reports every 2 years. Okay, so we also have a new procedure for handling complaints. This applies not only to advanced communication services and equipment which are used on the Internet, but also telecommunication services and equipment. So if you have a problem with your phone, maybe a phone is provided without sufficient amplification. I'm not sure, what kind of issues there would be. A lot of these focus for people on the people that are blind and visually impaired, but there are certain complaints that we also get from people, like a hearing aid compatibility complaint. If you file a complaint under the first section, under Title I, you have to first file with us. And let me go to the next slide and explain that. You have to request dispute assistance. So you can't actually first file an informal complaint for this particular law. You have to file a request for dispute assistance. And then our Disability Rights Office, that's DRO, we work with you for 30 days to try to resolve the problem. And then if the problem isn't resolved for 30 days, you have two choices. You can extend the 30 days or you can move to an informal complaint. The nice thing about this process is that once you file an informal complaint, our Enforcement Bureau must investigate and issue a final order within 180 days. That didn't happen before with Section 255, and often complaints weren't addressed in a timely fashion. And there's also specific remedies that we can implement up to $100,000 a day for a violation and up to a maximum of $1 million. We can require compliance within a reasonable time in the next generation of equipment, and we can actually assess damages. So there are some changes also in the CVAA to the telecommunications relay service. The most important one that you need to know about is the second one listed here, and that's that it updates the relay definition both to include people who are deafblind, but also to allow for calls between one type of relay and another type of relay. So if you're using, for example, caption telephone and you want to call somebody that uses video relay service, you can do that now, even if it's going to take more than one communications assistant to handle the call. We also launched, pursuant to requirements under the CVAA, something called the National Deafblind Equipment Distribution Program, which now provides $10 million annually for the distribution of equipment to low-income people who are deafblind. The equipment that can be distributed is equipment to make telecommunication services, internet access services, and advanced communication services accessible. And we also cover the cost of training, warranties, repairs, etc. So 53 state entities are now certified to get this equipment. And we also have a national outreach coordinator that has been doing a fantastic job educating the community. They have a website. It's called I Can Connect. If you know anybody that's low income and is deafblind, please send them to this website, and they're going to learn all about the program. We have given out hundreds of pieces of equipment to thousands of deaf people around the country. So, no, it's the other way around. I always do that. It's thousands of pieces of equipment to hundreds of deaf people because you can actually get more than one piece of equipment. So sometimes we get two or more. Another part of Title I of the CVAA requires emergency access to 911 by people who have disabilities. Because of this requirement, or in large part because of it, the FCC has an ongoing proceeding to ultimately make text to 911 possible. Right now, there is a voluntary commitment to roll out text to 911 by May 2014 by 4 of the major wireless carriers. Until everybody has text to 911, there's also a bounce back requirement. So generally, let me just say from the outset, we are not encouraging people to use text yet, because even though it's being rolled out by the carriers, not all of the 911 centers have text to 911 capabilities. So even if you can send a text to 911, it may not be able to be received. So if you can use your voice, we're telling you to keep using your voice. If you need to use text, we still tell you to use TTY for now or relay. But if you do have, by chance, if you use text, if somebody uses text, they haven't gotten this message from us that you shouldn't really use it yet, then for now there's a requirement for the wireless carriers to send a bounce back message from the public safety answering point, which is called a name for the 911 center, that says we can't accept your call. So that is part of the text to 911 requirement. This is an ongoing rulemaking. We still have lots to do on it, but it was in part prompted by the CVAA requirement. We also have something called an accessibility clearinghouse, which was required by the CVAA as well, and you can go there to try to find accessible equipment. And I believe I am not sure of the current website because they keep changing it on me, but if you type in FCC Accessibility Clearinghouse in Google, I'm really hoping that you get it. Or if you go to our website, www.fcc.gov and type in Accessibility Clearinghouse. You will definitely get it. And you can surf our clearinghouse depending on what kind of phone you want, what kind of disability you have, etc. So Title II of the CVAA is also very, very important to you. And I mentioned some of the things that we've done in this. This is an overview. I'm going to skip this to move on. The most important aspect of this section of this Title II that you're probably interested in is that it requires that when a television program is shown after it's shown on television, or if it's shown on television simultaneously and it goes onto the internet, it has to be captioned. This applies to pre-recorded programs, live programs, and near live programs. When it goes onto the internet, it has to be captioned immediately. So, in other words, you cannot take a program from television and put it on the internet and wait a couple of days and then caption it. You can't put it on the internet unless it's captioned. There's one exception to this rule, and that's if it already had been on the internet on a particular website before our rules went into effect. That's called archival programming, and we have a different set of requirements for that particular type of programming. They have an extended period of time, but they also have to eventually provide captioning as well. The rules currently that we adopted, okay, there's something coming on my screen. There, it's gone off. Okay. The rules that we adopted do not cover outtakes or video clips yet. There was a passage in the legislative history of the CVAA that suggested or questioned whether clips had to be covered and talked about full-length programming. So right now clips are not required. We are reviewing that. I'm going to talk about that in a second. It also does not cover YouTube. So it doesn't cover any well, I'm sorry, let me rephrase that. If YouTube has something that's been shown on TV, it would cover YouTube. But it doesn't cover consumer-generated media. So it is not going to cover your favorite cat tricks that somebody puts on or you know, whatever individuals put on. It also doesn't cover pirated postings. It has to be official postings. I mentioned before that when some of us went to Congress, we also wanted programming that originated on the internet to be captioned. So programming like Netflix, Hulu, Amazon.com, if they created their own series, we didn't get that. Congress did not require programming that originates on the internet. So this only covers programming that has been shown on television. However, because of a lawsuit that was filed several years ago by the National Association of the Deaf against Netflix, that lawsuit resulted in a settlement. And Netflix promised to caption 100% of its programming by September of 2014. Yesterday, Netflix representatives came to the FCC and informed us that they have beaten that deadline, and as of this past January, have now completed 100% of their captioning of their programming. So that is remarkable, and kudos to them. We were just absolutely thrilled. It is not an easy task to do that. They had to make sure that the captions are compatible with, I think they said, over 600 video players. So it's really a monumental task, and we're hoping that others like Amazon.com follow suit, or Amazon Prime. I mentioned video clips. Okay, so nearly as soon as we issued our rules, which was in January 2012, consumers groups, including HLA, petitioned us to reconsider the exclusion of video clips. And they said that Congress wanted these to be covered. By the way, one of the things that we did say is that when full programming is chopped up, like 60 Minutes or any show that has like Saturday Night Live, if you're just chopping it up and putting it on the web, it does have to be captioned. We were talking about small video clips. But the consumers maintain that they should be covered, particularly news clips. And just a couple of months ago in December, we issued a public notice seeking comment on the application of IP captioning rules to video clips and asking for the extent to which consumers are denied access to this programming. And we are now meeting with the industry and consumers to figure out ways to possibly cover video clips. Some of you may have seen the agenda meeting. It was online when our chairman indicated that he is interested in perhaps changing our original ruling on video clips. So we're excited about that. Okay, so video devices, that's another section of Title II, and Congress did get rid of that 13-inch requirement. And basically now video devices of all sizes must provide captioning and video descriptions for people who are blind, and emergency access. That's a blind requirement as well. Also, Congress required easy access to closed captioning and video description through a button, key, or icon. This was a personal goal of mine. I have to go through around 14 different steps on my television to be able to access captions. And I could not figure it out myself. My cable company couldn't figure it out. I can't even begin to access the display features. I still can't. I mean, I had a technician set them up for me. This ruling that video devices must provide captioning also covers recording devices, TiVo, they must pass through captions, DVRs, you name it. If it records, it has to pass through captions. And the interconnection mechanisms also can't block, like the cables can't block the captions. So that's probably the most important of the issues for you, the captioning on the internet and the devices. The rest of the slides I don't think have as much impact on you, so I'm going to go through them quickly and then open up for comments and questions. There are requirements for video description. This allows for blind people to have narratives of what's going on a television program where there is no audio. But these requirements are much smaller than captioning only 4 hours of primetime or children's programming per week, and only on in certain markets and certain networks, etc. You already have requirements, or we already have requirements that require all emergencies to be information about emergencies on television, such as information about snows and fires and earthquakes and power failures. Those already have to be accessible to you visually, and typically they're provided through captions. If you're not getting that, let us know. However, there was no requirement before for blind people. If there was a requirement for news programming, but if an emergency newscast broke into a program, so it was emergency, like through crawls on the bottom, before all that was required was an oral tone for blind people, and now there's a requirement for that information to be provided on the secondary audio stream. I'm going to skip this slide. And then there's also a requirement for video devices to pass through video programming that has this emergency information, this secondary audio stream. So again, this is more for people who are blind and visually impaired, but I covered it just to show you the types of things that the law also covers. So what's left? We have a couple of things that we still have to deal with. Some of them are more technical than others, the ones that you may be interested in, again, on the video clips issue, hearing and compatibility. Our national, the NDBEDP is short for National Deafblind Equipment Distribution Program. We're actually operating a pilot right now. We now have to finalize permanent rules. We need to finish our text to 911 proceeding. This year we need to send in our second report to Congress. We always update our accessibility clearinghouse, and also, of course, we have to implement and enforce the rules. We can't just adopt them. So these are some deadlines. I won't go into them, but you have them at your disposal for the rules. Many of the rules, as you see, have already gone into effect. January 1st was a big one because that's video equipment for captioning. That means that's the requirement that captioning be passed through, not only for television, but also for IP programming. And then we have some extended deadlines for some of the video description and emergency access rules. So this is just a slide, again, that I kind of throw in actually for usually not for consumers, but if you're ever trying to make the argument for why you need accessibility, these are good arguments. Good business sense, it avoids burdensome retrofits, inclusion is better than exclusion, and of course, captioning benefits everybody. Everybody uses closed captioning. I mean, access benefits everybody. Everybody uses closed captioning. Vibrating mobile phones, slower phone menus. There are lots of benefits. The last couple of slides have contact information, and I just included, these are guides, fact sheets. We have a fancy name for them, consumer guides. They're fact sheets, so they'll give you a lot of information about what I just talked about. We're still updating a lot of our fact sheets, so not everything that I talked about is listed here, but this is a good sampling. And here's more helpful information, and I do have the link for the clearinghouse. If any of these links don't work, let me know, but I tried a lot of them, and they worked when I tried them. And at the bottom is my contact information. You're very welcome to send me an email. I do try to answer every email that I get. If I don't, and a couple of days go by, ping me and just say, I sent you an email and you didn't answer, because sometimes some days are overwhelming, and I just miss some emails. So I guess I'm going to turn it back to Nancy.
That was really great information, and appreciate the plug for convention. If you are interested in seeing Karen in Austin this summer, she's presenting on Friday, June the 27th from 1:30 to 2:45. We do have several questions, Karen, and I'll go ahead and read them to you so that they appear in the caption. You may want to just turn off your microphone until you're ready to start.
Okay, turn off my microphone, did you say?
Yeah.
Okay.
And then when I finish, go ahead. I'll turn mine off and you can turn yours on. The first question comes from Michael Wilcox. Could you talk for a few minutes about FCC relations with caption telephone companies and their recent rulings regarding the required $75 fee?
Wait, I'm sorry. You had said turn off my microphone, so I'm not sure I heard you, but I think that you asked about the $75 fee. Is that right?
That's correct.
That's correct. Okay. Okay. So the $75 fee that the FCC had originally put into its rules is now suspended. There was a court challenge that was filed by Sorensen, and that fee had to do with obtaining a caption telephone device. The reason that the fee was put into effect was that what we were finding was that there was an enormous increase in individuals beginning to use caption telephone, and there was real concern that some of the providers were giving out equipment to people that did not need it. We looked, there was some effort to determine whether or not we should establish an eligibility criteria, a certain level of dB loss, instead as a way of screening people. Unlike television captioning, which everybody can have because it's free, when you use caption telephone, every single minute is charged to the federal government, which is then paid for by telephone subscribers. So we need to make sure that only people that really need this service are using it. What some of the providers told us that had been charging for caption telephone was that they felt that payment of a fee for the device was sort of a natural way of screening out people that didn't need it, because you were less likely to purchase the device if you didn't need it. So rather than use a dB eligibility criteria, which we were afraid might exclude too many people that might need it, because HLA was very vocal about this, and you said that there's no one cutoff that can be used. we went to the purchasing cost of the caption telephone, although actually the actual costs are like $300, and most of the providers charge at least $99. We reduced it a little bit to $75. However, that has been struck. The concern is that the fund, the relay fund that pays for caption telephone is now nearing $1 billion. And it has started to attract a lot of cause for concern by some entities that are saying that if it keeps going up, it might be in jeopardy. So this was a way to try to make sure that only people that needed the phone would use it and others would be able to get it. And if you couldn't afford the $75, you could get it from the State Equipment Distribution Program. And we also had a notice of proposed rulemaking asking whether or not we should have certain waivers for people that are low income. But right now the whole thing is on hold. Okay, next question.
The next question comes from movie captions.
Do movie theaters have to caption? And Nancy, by the way, it's hard for me to hear you, so I'm going to try to repeat every question. Right now, there is no requirement for movie theaters to caption, but the Department of Justice is working on this. There's an open proceeding on this. And I believe that that proceeding will ultimately require some form of captioning on movie theaters. But we do not oversee that. That is not within the FCC's jurisdiction. That's from the Department of Justice. It's Title III of the Americans with Disabilities Act.
What about movie trailers?
If a movie trailer is on TV and it is under 5 minutes, it's not going to be required to be captioned. If it's on the internet, it will not be required to be captioned either, because there is an exemption on television, as I mentioned, for commercials and also something called interstitials, which are very short clips. So no, there's no requirement for that.
Okay. There are a few more questions. Are they going to rule of compatibility as well? I am very interested in hearing compatibility because I feel that theaters, movies, and stage are not compliant.
Okay, let me see if I got that one. You asked whether we're going to be revising our hearing and compatibility rules. Is that correct?
Right.
Because you're concerned about theaters being compliant? I'm not getting anything back from you, Nancy.
That's what she said.
Okay, that's what I thought. Okay. So, no, I mean, the question makes sense, because if you have more people using hearing and compatible, if you have inductive coupling, or if you have, I should say, the telecoil, then you can access a lot of locations that use inductive coupling, like movie theaters. So I actually get the question. We are, as I mentioned earlier, we are revising our hearing and compatibility rules, but those are still in a state of discussion, and so I don't have anything to report on those. But right now our rules are pretty comprehensive. We require nearly, the majority of wireless phones. All wireline phones have to be hearing and compatible. All cordless phones have to be hearing and compatible, and the majority of wireless phones have to be hearing and compatible. But we're looking at those rules as well to update them.
Okay, the next question comes from and that is required to meetings that appear or on TV.
And the short answer is yes. They have to provide, well, I shouldn't say necessarily caption, they have to provide access to their council meetings. That, again, is not a requirement for that we oversee. That is a requirement under Title II of the Americans with Disabilities Act, which covers state and local governments. They have to provide access to their programs and activities, and so If they hold a city council member, they have to provide access to that meeting. Again, I'm not an expert on how they have to provide access, but generally, especially if you need to participate, it would have to be through captioning. They may be able to provide transcripts in certain situations as well.
Okay, the next question is Fred Williams. Karen, do you know what is the status of approval of cell phone improvements for incoming call captions proposed by?
I'm sorry, you need to repeat that one. The status of something, and I didn't get the word.
Status of approval of cell phone improvements as proposed by Captions.
Oh, the status of captioning, that is also pending. I don't have anything to report on that.
Next question. Are there any plans? 25 networks to 50 or 75 in the near future?
And I assume that you're talking about the requirements for real-time captioning for local news programs. Right now, we're going to see if the enhanced electronic newsroom technique that I talked about earlier is effective. Because if it is, then we may not need to move to 50 or 75 networks or markets that have to provide real-time captioning. So we're going to give it a year, and then we're going to reassess.
One more comment. Cell phone captioning from Linda. About when captions will be available for cell phones.
Captions should be available on cell phones now. January 2014 was when our requirements went into effect, and so I know that they are available. Actually, they were available way before this on the iPhone. You should be getting it on your Android-capable devices as well, and Microsoft devices. If you're not seeing captions, again, it would only apply to television programs or programs that were on television and moved to the internet. If you're not getting access to those captioning access, then let us know and we'll look into it. I can't tell you how much I encourage you guys to file complaints. We need to hear from you. We need to know when something's not working. Complaints are very, very effective.
Last question. Do you have any idea when the Captions will be published in the Federal Register?
We are working on the caption. This is an incredibly long process. It's a huge document, and unfortunately, we are not allowed to just take the document and put it into the Federal Register. We have to summarize it, and so it's a detailed process of summarizing it, but we're nearly complete. I would say within 7 to 10 days it should be in the Federal Register.
Okay, I apologize. I think my speaking might not be compatible with your microphone. The last comment I have is in response to the criteria for captions. I can't imagine why a hearing person would resist unnecessarily, or as it is. If they think this is fun, it is not.
You know what? I'm sorry. I'm just not getting it. Maybe just repeat it again.
She says, can't imagine why a person would want this necessarily. As poor
why a hearing person would want the phone.
It is not.
Okay, you're talking about the caption telephone, right?
Right.
And you can't imagine why a hearing person would want the phone unnecessarily. Okay. one of the reasons is that some of the phones you can keep transcripts. So that's one reason. But it's not so much that we think that the hearing people are going to go out and intentionally defraud the system. We're really more concerned that people just out of ignorance, or you just may not know or understand that this is a phone intended for people with hearing loss, are going to get the phone. And unfortunately, we've had so much fraud in our telecommunications relay service program over the last 10 years. It's insurmountable. I mean, it's really, truly overwhelming, I should say. We've had, not so much in caption telephone, but in other areas of TRS, of relay services, video relay service and IP relay, we've had violations that have resulted in millions of dollars of payments back to the fund. And we just want to avoid any kind of situation like that. The other problem is that we're not sure that, if people don't understand what the phone is for, they could just decide, well, it's easier for me to see, to follow. I mean, I use captions. I don't always need captions, but I like it. And I like it on television. It's free. I use it. But if I don't know that it's not free, then I might, if I wasn't aware that the federal government was paying for it, would I use it? I think that that's the problem. So anyway, we're looking at this issue very, very seriously, and we're hoping that we can come to a resolution that makes it easier for people to get the phones, and yet also, doesn't burden the individuals, but doesn't allow the phones to go to people that don't need them.
Okay, I think that's all we have time for tonight. Thank you very much again, Karen. Really appreciate it. We'll see you in Austin.
Thank you. It's great to be here, and I hope to see you in Austin.
Okay, thanks.
Bye-bye.